Yeah, I complained yesterday, but I told them, so they obviously, well, they said something about they would lock open the bench. So apparently they have access to do something to open and close the bench. I don't know, but I mean, that's what I said. Well, I've got the thermostat but down, but it's going up. And I heard them saying in the background, okay, well, we'll do something with the vent. But now it is chilly, but I'm not going to complain because
Better than nothing.
see, Mr. Parker, you've got Edward Godfrey. It's a sentencing.
Edward Godfrey.
Good morning. Good morning. Are you Edward Godfrey III?
All right, here we go. This is where everything changes. The judge already has the pre-sentence report, which means she's reviewed Edward Godfrey's background, criminal history, and personal circumstances before saying a single word. What happens next isn't just about punishment, it's about whether this young defendant gets a second chance or a life-changing felony conviction. Pay close attention because the judge is about to explain one of the biggest legal opportunities a defendant can receive.
No. And Mr. Godfrey was previously here in cause number 26, DCCR 0383, entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, ma'am. Yes.
I'm sorry.
Yes, Your Honor.
Are there any additions or corrections?
None more, Judge. Not so.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. This is such an excellent opportunity for you. You're very young. You do not want a felony conviction on your record. It'll change your life in a very negative way, in lots of ways. You can't go to obviously certain jobs, schools, apartments, it just all kinds of things. And so part of your probation is going to be that you get your GED or finish school, one or the other. So if you're not going to go back to school, then you have to start that GED process within 30 days of today. That's not just for me, that's for you. That'll make it also everything in your life easier, getting better jobs and things like that. It's very important. It should be important to you. So I want you to get that done. You're going to go through some classes. You're going to do everything you're supposed to. Then at the end of your probation period, if you're successful, the case is actually dismissed. You never have a felony conviction. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon and you could go to prison for up to 10 years. Do you understand?
This is the moment every defendant should remember. Deferred probation sounds like good news, and it absolutely is, but it's also a legal tightrope. Complete every condition successfully, and the felony can disappear. Break the rules even once, and that second chance can instantly become a prison sentence. Would you risk throwing away an opportunity like this? Let me know in the comments.
You understand? And also, it is a condition of your probation that you have absolutely no contact, communication in any way with Ramsey Howard. Do you understand? Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. All right. Good luck to you. You can go back with the bailiff. Marvin Watts, Mr. Parker.
Good morning, Your Honor.
Good morning.
Mr. Parker. Morning.
Do I have,
He signed on your spot on one of, but I'm just fixing it.
in both cases or just one?
Just one.
He's putting on both cases. He
He
signed.
just signed one spot.
Oh, because I don't see any here yet.
Yes.
Okay.
Listen. Oh.
Hey, sir, are you Marvin Lee Watts
Julie.
Jr.? And Mr. Parker, will your client waive the formal reading of the indictment in each case?
That's Shannon.
Now the courtroom shifts gears dramatically. We're no longer talking about probation for a young offender. This case involves two separate aggravated robbery charges, both first-degree felonies. The stakes just skyrocketed. Instead of negotiating guilt, the focus now becomes one question. How much time could this defendant actually spend behind bars?
Mr. Watson, cause number 25, DCCR 1918, you're charged with the first-degree felony offense of aggravated robbery from October 2nd of 2025. And how do you plead to that charge?
Here's an important legal detail that often confuses people. A 17-year cap doesn't mean the defendant automatically gets 17 years. It simply means that's the maximum sentence the judge can impose under the plea agreement. The judge still has discretion to hand down anything within the agreed range after reviewing the evidence. And the pre-sentence investigation. That's why these sentencing hearings are so critical.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in clause number 26, DCCR 0946, you're also charged with a first-degree felony offense of aggravated robbery. This is from September 12th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of those cases, I have here on the tablets documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for a cap of 17 years in prison, which means you're leaving your punishment up to me. I can give you 17 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and decide two things. First, to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? So you have, what you've agreed to is a cap of 17 years, which means a cap, all that means is that you're leaving your punishment up to me. And you could, if you wanted, have a jury decide instead of me. But if we go forward this way with the papers that you've signed that says that you're waiving a jury and that you want me to sentence you within that range of punishment, which would be between 5 years up to 17 years, there's the possibility of probation. It'll all, again, depend on what information I get when we come back for sentencing. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Watts is not competent?
Second.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases for when we come back for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf. Okay.
Yes.
Right, you can go back with the
Thank
baby.
you, Judge. Thanks for getting me in.
Yes, sir. Mr. Macon, you have Cyprian Avedontu. Yeah,
That's what, Your Honor.
it's not even close, I'm sure, but Avedonute?
Romania. What's the name, Judge?
Cyprian Avedonute.
You got
You didn't want to relay that? Good morning. Good morning.
How you doing?
Welcome. I just realized now that I'm reading them, I'm noticing that they're backwards. What's like that? No, they changed it and she's getting it changed back. Yeah. Good morning.
Good morning.
Notice how different this hearing feels. Instead of rushing toward a plea, both sides are asking for more time. That's actually common in criminal court. New evidence, interpreter issues, and recently appointed attorneys can completely change the direction of a case. Sometimes the smartest legal move isn't arguing, it's slowing everything down until everyone has the full picture.
And are you Cyprian? Is it Avedonatue?
Yes.
Close enough. All right. And Mr. Avedonatue, I can't say it, is charged with unlawful interception or use of a wire oral electronic communication. And Mr. Macon, what is the announcement?
Yeah, I'm going to call him Cyprian. He just got back here from California. He was in custody out there and they brought him back. And Pam was just appointed on the case. And I really haven't got with her to discuss all the things. Plus, I have a Romanian interpreter interpreting quite a few papers that show my client was out of the country. But I would ask for a normal resetting.
Okay.
I'd work on all that.
All right. And Ms. French, any issues with the
No,
reset?
I've been given a thumb drive with information on it, and I'll be reviewing that as well. So I appreciate the reset.
All right. We'll just do a normal reset and then we'll see where we get the next court date. You can go back with bailiff. Mr. Kelly, you've got Dalton Batiste.
Judge, that's Mr. Coleman's hold on to that case. Can you hold it just for a minute? Because he knows Mr. Kelly's here.
Sure.
He's gonna come out with it.
Thank you.
Thanks.
I'm waiting.
Not yet. I'm sorry.
Not at all. Thank you very much. Thank you very much. Very well.
See, Mr. Lewis, you've got DeJuan Banks.
Yes, ma'am.
DeJuan Banks.
Right.
No. It just was amazing. And
Morning. How are you, Mr. Lewis?
I'm doing all right. That's fine.
Good.
This may sound like a routine scheduling discussion, but it's anything but routine. Cases involving children often become complicated because prosecutors need accurate information about the child's location, caregivers, and well-being before deciding how to move forward. Listen carefully, the attorneys aren't just talking logistics. Here, they're making sure they have the evidence needed before taking the next legal step. Sometimes the smallest courtroom conversation carries the biggest consequences.
Good morning. Are you DeJuan Banks?
Yes.
And Mr. Banks, in cause number 25 DCCR 0990 is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Well, Judge, when last setting he was here, I think it was some issues where the state was trying to locate what placement where the child was, so we can try to move this case along. We have since found that information out recently. He is out of state. So I know now they're,
Judge, if it makes sense to you, and Mr. Lewis has been nothing but helpful to me, and we have talked about different offers that one would expect would resolve the case if guilt was really on Mr. Batiste. What I'm trying to do is find
Banks.
bank. Sorry, I'm sorry. I'm 30 seconds behind. Sorry about that. If that makes sense what I'm saying without saying it out loud. The child is in the custody of family members but under the care of foster care. So when I look from everything I have access to, it looks as if the child is in the care of foster care, which is where I have been going to try to locate people to speak with. But now the child is in foster care, but with the family, if that makes sense. And I wouldn't know this information but for Mr. Lewis, which is now who I need to speak with. I know it says final. If we need to put it on the trial market, obviously that will be done well in advance of when that trial market would be. That's
No, I guess
just
you're
a
saying you
issue.
now have, you know where you.
Yes.
Okay.
Even though all the logistics say foster care, the child is still in foster care, but is with the
Okay.
grandparent.
I'm going to do one more reset to give you some time to get a visit with them, and then let's get an announcement at the next.
And they have been generous with that information. Otherwise, I wouldn't know where that child is other than through the foster care system. And he's not a possessor of custody, so to speak.
All right. Thank you. You can go back with the bailiff.
Thanks.
Thelma Gilbert.
Gilbert.